Good morning. Good morning, Namaskar, everyone. This is Engineer Suraj Singh speaking from Bharat, India on this day, November 3, 2021, Wednesday. Now it's about 3:50 a.m. मैं सूरज सिंह सिविल इंजीनियर भारत इंडिया से बोल रहा हूँ। आज नवंबर 3, 2021 सुबह करीब 3:50 बुधवार। और ये टॉक आपके लिए क्वालिटी के लिए, स्टैंडर्ड्स के लिए। दिस इज फॉर यू एंड this talk is about quality and safety, health and environment. Title is Civil Field Engineering and it's a combination of Hindi and English. Dominance shall remain English, but some transactions, some translations of few important tenses, important points be made in Hindi also, because Hindi is also in demand in our country, Bharat, India. Particularly about 50 to 60% people, they understand language Hindi. Some people don't like English, but English and Hindi is a requirement for all to understand, and many countries in Gulf also understand Hindi or Urdu. Engineers and life, जीवन और अभियंता, quality is गुणवत्ता, and this contract, red, silver, safety, health, and of course design. डिज़ाइन तो डिज़ाइन ही होता है, कैसे कुछ किया जाए कैलकुलेशन के बेस पे, कुछ को फाइनल करने से पहले उसका प्रोसीजर, दैट्स कॉल्ड डिज़ाइन। कोई भी काम डिज़ाइन करके करना। कंस्ट्रक्शन मीन्स निर्माण, एंड मेथड्स मीन्स तरीका काम करने का। कॉन्ट्रैक्ट्स मीन्स एग्रीमेंट्स, करार, दो पार्टी मिलके कैसे पहुँचें एक फैसले पर। ऑर्गेनाइजेशंस, कोई भी कंपनी हो, गवर्नमेंट हो, डिपार्टमेंट हो, पब्लिक हो, कुछ भी हो जो इन्वॉल्व है इंजीनियरिंग में, मैन्युफैक्चर में, इंडस्ट्री में, इन कम्युनिकेशन एंड कोऑर्डिनेशन विच आर ऑफ utmost importance. Communication and coordination, as we say, communication, very important part of works. Communication and coordination, in fact, are real passage formula to understand and to make others understand. खुद समझना स्वयं और दूसरों को समझाना। संचार कहते हैं कम्युनिकेशन को हिंदी में, और कोऑर्डिनेशन का मतलब तालमेल। तालमेल का मतलब आप समझते हैं, एक दूसरे से साथ मिल के चलना, सही समय पे चलना। कोऑर्डिनेशन क्या होती है? कितने भी प्रॉब्लम्स आए, जिस समय जो काम करना है, सारे प्रॉब्लम्स को एक साथ लेकर, सारे क्वेश्चंस को एक साथ लेकर, सारी आवश्यकताओं को एक साथ लेकर आगे चलना। टू पुल एवरी रिक्वायरमेंट इनटू योर क्वेश्चन, योर पॉइंट, फोकस, एंड देन मूव फॉरवर्ड, दैट इज कॉल्ड कोऑर्डिनेशन। एंड हमेशा क्वालिटी की बात करना शायद लोगों को अच्छा नहीं लगता। I don't care it looks fine or it doesn't look fine, but we cannot run away from facts. You cannot run away from facts, and particularly engineers cannot run away from facts. हम सच्चाई से, हम ट्रुथ से भाग नहीं सकते। हमेशा हमें सच्चाई पर ही चलना पड़ेगा। वी हैव टू, क्योंकि झूठ की ना बॉडी होती है, फॉल्स और फेक falsehood got no body, it got no legs, it got no recognition. It's truth only, सच्चाई है जो हमेशा आगे लेके जाती है। टाइम लग सकता है, it can take some time. It has got no shortcuts. Shortcuts means you don't want to do work. I don't believe in shortcuts, I believe in real cuts. Whatever time is required to be taken by something, that time is a requirement, and that's it. You cannot shorten it, you cannot reduce it. If you want to shorten it, if you want to reduce it, you are going to shorten everything. Keep in mind, don't trust in shortcuts and don't trust in thumb rules. Shortcut का मतलब काटना अपने आप को, थंब रूल का मतलब अपने आप को बेवकूफ़ बनाना और दूसरों को बेवकूफ़ बनाना। ना कोई शॉर्टकट काम करता है, ना था एक्सपीरियंस ज़रूर काम करता है। एक्सपीरियंस इज़ वेरी इंपॉर्टेंट इन इंजीनियरिंग एंड इन लाइफ एज वेल। विदाउट एक्सपीरियंस, एक्सपीरियंस इज़ नथिंग बट लर्निंग। Experience is practical learning. What we do, how we do, and by your own experience means by your own doing. When you do something, you know what is right or what is not right, what is correct or what is not correct. We understand that during phase of working, and that is important. You communicate yourself. Communication also occurs, maybe we do not communicate others but to ourselves. When I work, I learn something because I communicate, I read, I observe, I understand. No one can work by closing eyes, by closing minds. Then you cannot work. Self communication is very significant. Then communication, one to one communication and one to all communication. Communication with whole world is very important. We cannot say no that point. We have to understand that point. मुन्नी 4 बज गए। मुन्नी इसका मुश्किल है। Without communication, you cannot do anything. I think education is communication of reality. When you go for education, you have communication with teacher and teacher gets communication with you. You communicate with teacher, student communicates with teacher. When you read book, you communicate with author of that book. Same way when you write, you communicate with your memories or with your understanding. Life is full of communication. How many times you communicate in a day? Maybe you do not know. You never count it. When you talk to your parent, you talk to your siblings, you communicate. So communication is everywhere. It's no secret. Only difference is that when you use your mind for communication, it's learning or teaching, and one is ordinary communication that's based on convention, general talks, interactions, chatting, that doesn't require much more mind. So where mind is used, that communication is converted to coordination, because when you use mind, your mind pulls other problems also, other issues, related issues also. Many issues come to same focus, and that's you have to interpret each one that they should tally with each other. They should work in consonance with each other, and that's called coordination. In engineering, It may be design engineering or it may be works engineering. I call it works engineering means when you do works on site, you can call it, people call it site engineering. I may call it site engineering or works engineering. Both are full of communications and coordination. Why we worry about that? We worry about that because of requirement. I close this file sometimes so that it's better not to be, these files I close and I then, so that my, now why I'm talking about this. We're talking about products. We talk about quality, economics, contracts, and we can say there's nothing that we have to do additionally on this but keep on improving that one. Quality means it's kind of something, it should be present everywhere. Quality, it should be in your food, it should be in your mind, it should be in working, it should be in your personality, it should be how do you conduct with others, and it should be how do you conduct with work, and whatever else activity that we do, we conduct, everywhere we have to involve ourselves with quality. Whatever quality you do, it may be good or bad, both are there, both work together. Good quality means good work and bad quality means bad work. Results of both. It depends on what you prefer to do. So preference is difference. Quality is not something that is unknown. When we say quality, we define limits of quality, we define its boundaries, and we have to define that. It's not defined automatically except nature. We cannot control nature, but at least we can control our acts. Nature is very big, it's immense, infinite, and we are not that. If we compare our works, we are very, very small scale in comparison to nature scale. We are very small, even then we jump a lot, we vibrate ourselves. I've done this, he has done this. But what we have done, I think we have used something. We have not done anything. We got something from nature and we do that. In engineering we say, engineering means we have to use natural resources optimally. What does it mean? We have to use natural resources optimally. हम इंजीनियरिंग में कहते हैं कि जो भी मटेरियल है हमारे पास, रिसोर्सेज हैं हमारे पास पृथ्वी से दिए हुए, उसका हमें बेस्ट यूज़ करना है, अब्यूज़ नहीं करना है। उनको हमें सही तरह से प्रयोग करना है, सही तरह से जीवन में उतारना है, उनका अब्यूज़ करना है, उनको ख़राब नहीं करना है। लेकिन हम तो ख़राब कर रहे हैं। बताइए कौन सा नेचर का प्रोडक्ट है, कौन सा प्राकृतिक साधन है जो हमने सही प्रकार से यूज़ किया, इस्तेमाल किया। मुझे नहीं लगता कि हम अच्छे विश्व के नागरिक हैं। हम प्रकृति का स्वागत करते हैं, प्रकृति की परवाह करते हैं, केयर करते हैं। हम समझते हैं कि प्रकृति हमारी है, लेकिन कहने के लिए हम तो प्रकृति को ख़राब कर रहे हैं। वी आर स्पॉइलिंग, वी आर पॉल्यूटिंग एवरीथिंग दैट हैज़ बीन गिवन टू ह्यूमन। हम कोऑर्डिनेट नहीं करते प्रकृति से भी। हम सब तरफ गंद फैला चुके हैं। वी हैव स्प्रेड डर्ट एवरीवेयर, वी हैव पॉल्यूटेड अर्थ सरफेस, वी हैव पॉल्यूटेड वाटर बॉडीज, वी हैव पॉल्यूटेड एयर, and in fact we have polluted our minds. That is very dangerous. Our minds in this era only thinks of economy, our mind only thinks of material, our mind only thinks of how to get more and more rich. Rich in what connection? We have no answer. Is nature rich? Are we to question ourselves? क्या प्राकृतिक अमीर है, प्राकृति गरीब है? अगर वो अमीर गरीब है तो किस स्केल में, और हम उस अमीर और गरीब पृथ्वी पर हैं? वी हैव टू थिंक ऑफ दैट. Economy has become a poison for whole world. Up and up, down and down. Economy has crossed existence. Economy has become, it should be a tool rather than use. Just like we say computer is a tool, but we have become slaves to computer. इस तरह से कंप्यूटर को कहते हैं कि हमारे को यूज़ करने के लिए है, हमें कंप्यूटर यूज़ करना है, लेकिन हो क्या रहा है, कंप्यूटर हमें यूज़ कर रहा है. That is a problem. We don't know how to use quality, how to understand quality, how to demarcate it in our life. That is very much required. Youth has a responsibility. I cannot explain to kids, but youth who are matured enough, who understand bad and good, they must take care of this. It's very important that ultimately, because youth have future, they have to use all this. Those like me who are on brink of, can say, on edge of going away, I can't say about them, but youth is youth, and youth has to understand this fact. To improve quality means to improve all aspects of life. It's not only quality of works, it's quality of life itself. If we can understand quality of life, and quality of life doesn't mean material. Quality of life doesn't mean good clothing. Quality of life doesn't mean your luxurious items. I have a bungalow, I have a car, I have this facility, I have that facility. That is, you can say, yes, it can be requirement for someone, but it is not luxury. It should not be used as luxury. What is luxury? Why you want to be luxurious? Means you don't want to do anything. You just want to enjoy life. You don't want to sacrifice. You don't want to do hard work. That is life, you think? That's not life. Life and quality are related. Your life should be useful to world. Your life should be hard working, not just to make money. Okay, if you make money, you have to think that can you take this money with you? You have to leave everything here. That is fact. We cannot say this house shall go with me or it shall not go. Same way, quality work shall remain on earth. It may be in bad quality or it may be good quality. If you do bad quality, you won't feel happy. It is also true. If you do good quality work, you shall feel certainly happy that I have done something for some good cause. Even if you don't get money, what money you expected for, that money of happiness is your money. This really money. Money in sense that you got something for others. Just like we say some student passes examination by hard work, by hard study, by very efficient working, that student feels very happy when results are good. And if that student if copies something in examination, that student can never feel happy, because throughout life that copying factor remains with that person, that boy or girl, and throughout life that guilt remains in mind. Oh, I had copied this, and that cannot go out of mind, because that is bad quality work. Bad quality cannot be equated to good quality, and that is one requirement. मुझे वही लगता है यार, ये बहुत मुश्किल है इसको बताना. आपको ज़िंदगी पर गिलवा शिकवा रखना है अपने माइंड में कि देखो मैंने वहाँ कॉपी की थी, और वो ज़िंदगी भर आपके साथ रहेगा माइंड में। लेकिन जब आप पास करेंगे ईमानदारी से, मेहनत से, तो वो कहेगा आपके मन में, ऐसा जम जाएगा कि आपने कुछ किया लाइफ में, और वो याद रहेगा देखो मैंने वहाँ मेहनत की थी, आई वर्कड हार्ड देयर, आई स्टडी वेरी वेल एंड गॉट गुड रिजल्ट, एंड दैट शैल बी अ फ्रेंड, दैट शैल बी अ गाइड फॉर एवर. That kind of mechanism helps. That kind of internal mechanism, I call it internal mechanism. That's why I'm interested in talking about quality system. Quality is soul of life. Quality is soul of work. Quality, of course, it cannot be separated from work, but it can be abused. It can be abused for sake of time, for sake of money. If you want to do quality work, you have to understand what to do. You cannot work haphazardly. You have to plan something, you have to decide something. You have to find a way, and once way is decided, then you can say, okay, fine. Now in construction, in manufacturing, particularly I'm talking of construction, because quality is very big issue in construction world. When we talk of construction, निर्माण जिसको हम कहते हैं, उसकी बात करते हैं, तो हम बहुत बड़े अमाउंट की बात करते हैं. विश्व में कंस्ट्रक्शन ऐसा दुनिया है जहाँ हमारा सारा पैसा करीब करीब लगता है. ऑन एन एवरेज everybody spends money on house, spends money for office, and whatever you do, you spend money. Every nation spends money on roads, on infrastructure, on other systems. Construction means you have to produce something that is called asset, that can be valued in terms of your power. What is your economy? You say, when you count economy, you say assets evaluation, value of assets, how many assets you have. And assets are produced by engineering perfectly. Engineering is not a phase that you just eat and throw. It is something that gives you for years to come, for decades to come. We have to keep this in mind. हमें अपने माइंड में रखना है कि इंजीनियरिंग ऐसा काम है जिससे हम प्रोडक्शन लेते हैं. वो फिर कोई भी प्रोडक्ट हो, कोई भी कंस्ट्रक्शन हो, कुछ भी हो, उसके बिना हम आगे नहीं जा सकते. इंजीनियरिंग इज़ दैट, एंड दैट्स व्हाई इट्स कॉल्ड इंजीनियरिंग, बिकॉज वी यूज़ माइंड, एंड इंजीनियरिंग मीन्स यूज़ ऑफ माइंड. अगर आप माइंड यूज़ नहीं कर सकते तो आप इंजीनियर हैं नहीं. वैसे तो हर स्टडी में, मेडिकल में भी माइंड बहुत यूज़ होता है. हर स्टडी में यूज़, एवरी प्रोफेशन रिक्वायर्स यूज़ ऑफ माइंड, एंड इंजीनियरिंग इज़ लीड, इट्स लीड वन. इफ यू कैनॉट यूज़ माइंड, यू कैनॉट डू एनीथिंग. और माइंड अगर क्वालिटी में, सेफ्टी में लगाएं, इफ़ यू यूज़ योर माइंड इन डिसिप्लिन ऑफ क्वालिटी, और इन यू कैन से integration of quality in your work, quality in your approach, quality in your thinking, we can serve God, because we use natural product. How to use them perfectly, safely, economically, we call that also quality system. We have no right to abuse God. We have no right to abuse nature. That's the main point here. And we deal with contracts, because contracts means construction. Contracts means construction, and we deal with that. And that's real point here, we can say, where engineers are involved in construction. Engineering team is involved everywhere. And we say construction based on reasonable, coordinated, constructible quality designs. We do designs, yes, we do designs. We do construction. First, design is a part of construction, because without designs, construction cannot be done. If it is done haphazardly, and that got no meaning, that got no plan. We have to plan perfectly, and that's called design. Design means, of course, budget should be there, but I'm talking of perfect design. Design means we have to think of what we are going to do. We must have some concept, some dream that we have to do that. We have to focus on that. And that focus then generates design in mind, and then mind generates design or transmits it on paper, and then we have to work out on that. So design has also got many stages. You can say it's a conception, it's a kind of thought, school of thought, framing, and that framing thinks on itself's mind. How shall it work means without even putting on paper, you think in your mind how this design is going to work. And then you reflect your thoughts onto paper and then further work on that. So that is conception to development, and development to delivery of designs through detailing is done. So designing has also its own domain, which is very wide, extensive, cannot be controlled otherwise. You have to think of that. Design is that part of life. And then that design which you have done with hard work, with refined thinking and contemplation, that should be transferred to work on sites or you can say manufacturing or whatever it is. I'm talking of construction. So here focus is construction, and that should be transferred to construction perfectly. And here also, school of thought applies. Intellectualism applies here. Though it's said that it's a layman job, people say that, but they don't understand those lay people are very brilliant, very hardworking, and if those people don't work, we cannot get our works done. Even if we have machines, if operator doesn't work, machine cannot work. If we have automatism, even automatic system, it doesn't work. There should be someone to control that, to monitor that. If that person is not available, we cannot do anything. And that's why design and construction are related to each other by soul, not by material even. You can say they are related to soul, they are related with each other integrally. It's like, kids, it's like siblings. Design and construction are samely, same soul, same body. Body is created, which is design thought of, and that body is called practical physical work. Now how that body complies with design requirement, that is called quality. Does it fully comply with, or it complies with part, or why did it not comply? All these issues have been raised through engineering, and that's what quality is there. It's not simply physical building. We call it building with requirements, or soul of building, soul of structures. Designs are done using mind, and construction is also done using mind, but with support of physical resources. And those resources, number one is human resource, other resources equipment, then resources materials, likewise, and then you can say we have to use combination of all these resources to reach some destination, and that destination, that focus is our product, our structure. Structure is not easy. It's something, you may call it practical based on hypothetical, practical physical world based on some quality imagination. It's not dream alone, it is calculated dream. When we think of structures, designs, we think of lot. Maybe only public know little, but every engineer knows what it is going to do. अरे उठ जा, फिर सो गई लगता है। मुन्नी, तो ये तंग कर दिया इसने। मुन्नी, 4:20 हो रहे हैं। Yes, contract There's a contract here. It says that it is a form and is about notices and other communications. What does it say? It's a silver, you can say silver book, condition of contract, or you can say EPC turnkey projects. And what it says about communication, notices and other communications. Wherever these conditions provide for giving of a notice, including a notice of dissatisfaction, or issuing, providing, sending, submitting, or transmitting, or another type of communication, including acceptance, acknowledgement, advising, agreement, approval, certificate, claim, consent, decision, determination, discharge, instruction, no objection, records of meeting, permission, proposal, record, reply, report, request, review, statement, submission, or any other some similar type of communication. Notice the other communication shall be in writing. See आप how many कितना लंबा खींचा है इसको. See how many points are there. Let us see one by one. It says wherever these conditions provide for giving a notice. अगर इन शर्तों में इन कंडीशन नोटिस देना है आपको किसी को भी, ये हम बात कॉन्ट्रैक्ट की कर रहे हैं, जस्ट कीप इन माइंड, इस पर नॉट टॉकिंग समथिंग एल्स. Wherever these conditions provide for giving a notice, including a notice of dissatisfaction, or issuing, providing, sending, submitting, हमें भेजना है, इशू करना है, देना है, प्रोवाइड करना है, भेजना है, सबमिट करना है, ट्रांसमिट करना है, जिसमें स्वीकार हो गया कोई एक्सेप्टेंस है, एक्नॉलेजमेंट है, एडवाइसिंग, एग्रीमेंट, अप्रूवल, सर्टिफिकेट भी है, क्लेम, कॉन्सेंट, कितने पॉइंट्स हैं, डिसीजन, डिटर्मिनेशन, डिस्चार्ज, इंस्ट्रक्शन, नो ऑब्जेक्शन, जो भी हमें करना है, नो ऑब्जेक्शन ऑफ मीटिंग, परमिशन, प्रपोजल, रिकॉर्ड, ये सब के लिए कम्युनिकेशन चाहिए. आई रीड अगेन so that you can understand well. Wherever these conditions provide for giving a notice, wherever these conditions provide for giving a notice, you can say wherever these conditions provide for giving a notice, giving of a notice, you can say a notice of dissatisfaction, or issuing, providing, sending, submitting, or transmitting of another type of communication, including acceptance, agreement, you may say acceptance, acknowledgement, advising, agreement, approval, certificate, claim, consent, decision, determination, discharge, instruction, no objection, records of meeting, permission, proposal, record, reply, report, request, review, statement, submission, or any other similar type of communication. Notice how other communication shall be in writing. इन सब के लिए you have to give in writing. बातें करने से बात नहीं बनेगी. What shall be in writing? It shall be a paper original signed by contractor's representative or employer's representative, as case may be. A paper originally signed by contractor's representative, और अपना उस पेपर को साइन करना पड़ेगा, चाहे कॉन्ट्रैक्टर का इंजीनियर साइन करे या एम्प्लॉयर का इंजीनियर साइन करे. रिप्रेजेंटेटिव में इंजीनियर बोल रहा हूँ यहाँ पे फॉर योर क्लियरेंस, का कन्फ्यूजन ना हो. कोई भी साइन करे, साइन तो करना पड़ेगा, बिना उसके नहीं जाएगा. दैट्स ट्रू. एंड इलेक्ट्रॉनिक्स ओरिजिनल जनरेटेड, अब तो इलेक्ट्रॉनिक का ज़माना है. एन इलेक्ट्रॉनिक ओरिजिनल जनरेटेड फ्रॉम आउट ऑफ सिस्टम, यू कैन से, ऑफ इलेक्ट्रॉनिक ट्रांसमिशन स्टेटेड इन कॉन्ट्रैक्ट डाटा. जो भी कहा है कॉन्ट्रैक्ट में, ये आपका ये प्रोसीजर रहेगा, और नहीं है तो एक्सेप्ट करना पड़ेगा. जो भी एम्प्लॉयर चाहे वो, क्योंकि एम्प्लॉयर ने पैसा देना है आपको, जो भी वो तरीका चाहता है वो तरीके से आपको इलेक्ट्रॉनिकली देना पड़ेगा. यू हैव टू गिव इट एन इलेक्ट्रॉनिक ओरिजिनल generated from either of systems of electronic transmission stated in contract data, and if not stated systems acceptable to employer, where electronic original is transmitted by electronic address uniquely assigned to each of such authorized representative, or both. Now, as stated in these conditions, let us say what it is. It is a notice. If it is notice, if it's a notice, it shall be identified as a notice. अगर ये नोटिस है, नोटिस का मतलब सूचना है लेकिन ऑफिशियल है, कोई मजाक की सूचना नहीं है। हमने आपको कह दिया था, आपने सुना नहीं। इट्स नॉट लाइक दैट। इट्स अ नोटिस identified as a notice or titled as notice, and if it's another form of communication, it shall be identified as such. Whatever communication it is, it shall be identified as such. Whatever title it must have, should have, and include reference to provisions of contract under which it is issued where appropriate. एक खास बात और होती है, कम्युनिकेशन दो तरह की होती है। एक तो भाई ऐसे हमने कह दिया चलो कोई बात नहीं है, हमने बता दिया आप ऐसे काम कीजिए, आपको समझ नहीं आया तो ऐसे कर लीजिए। We just say okay, do like this, do like that. That got no reference, nothing. But there are certain recordable communications, very important communication which may be used in future for disputes resolution or for record purpose or something else. बहुत सारी बातें होती हैं we have to use in future, and those, because it is a contract, we have to understand why I am writing that. Is there a reason I have to record this? Is there something that may be useful in future for references? कल को कोई बात होती है, कुछ होता है तो हमको इस कागज़ की ज़रूरत पड़ सकती है, इस राइटिंग की ज़रूरत पड़ सकती है, and that's really important point we have to note, because contract sorry because contracts कोई एक दो घंटे में ख़त्म नहीं होते हैं. Construction contracts move on for years, year, 2 year, 3 years. It doesn't, I cannot say at this moment, but years and months are involved, and during that period there will be so many instances when you have to talk, you have to write, you have to do something, you have to make mistakes, you have to solve mistakes, you have to find some solution, or you have to instruct someone, you have to get instructions, or whatever it is. Means who is responsible for what, or what did the contractor do and what did the engineer do. All those points are important to talk in future, but if you do not write something, we cannot talk that. There are so many such issues we can say. For example, contract is working, engineer wants to say something, resident engineer wants to say something, the contractor wants to ask something. All these questions and answers, all these requirements must be fulfilled in writing if possible, because I cannot say everything should be in writing, but important points should be in writing that can affect your contract in future. वैसे तो दिन भर हम 10 घंटे 12 घंटे साइट पे होते हैं, we remain on site for 10 to 12 hours or more, and there are so many instances where talk to each other, we talk to engineers, resident engineers, and contractor talk to others, and they talk to contractor. Everything cannot be in writing, but important points, important decisions is right, that can affect job, that can affect progress, that can affect everything. That's called notice. But notice means statutory notice. No, it's contractual notice, and other one is just indicative notice. Up now, if somebody says to you, resident engineer says to you, okay, do it like this, there's some problem in this, so I'll instruct you, or I'll give you some memo. Then memo, you say, I'll give some memo, memorandum, that is different. This is kind of ordinary communication, just like we something do this and we record that. There can be instruction also, and there can be something that's more important than that. So if we can say that all these should be somewhere record, it's important. But what I was saying is reference to contract. When something is given in conditions and we want to talk on that, this means we talk contractually. We're not talking normally. It's not normal site conditions. That's why I'm differentiating between normal work, normal writing, or normal talk, and conditional talk, or you can say contractual talk. Normal talk means as we meet together, so good morning sir, how do you do this and that. So normal talk means okay, how you are working, what's going on, this and that, what activities you are doing. These are all normal informative talks. Or you can say logistic inquiry, what's happening on site, is there any problem, do you have some problem, do you want some help. These are all natural talks. But when there is something that you have to record, you want to do something, no, this commercial question, some even consultants sometimes or engineers say, okay, this may be for your commerce, no problem, you can ask question, we can answer you. Means if there is something is related to conditions of contract, you are pinpointing that when you pinpoint that, then you can say under this condition, general condition or particular condition, or under this specification, this provision has been made, or in line to this requirement, I am submitting this letter. That is called contractual communication, where you are putting in, you are referring to certain clause, certain conditions in contract, and that is really very important point we have to understand. That point is not easy. That point makes a difference. So we have to be very clear about that. Two types or many types of communications are there. It's not simply communication. Sometimes we talk to many people, and even sometimes engineers or representatives can say, okay, you write to me this one for purpose of decision making. I will forward it, I will take a decision, but keep it on low profile or keep it on contractual profile. When you say keep it on low profile or some higher level profile or on contractual profile, these profiles are different. When you say contractual profile, means this is a part. This is going to be recorded as contractual, and where you can start reference to conditions are given, which you can say can become a binding on both parties to contract, and those parties means employer and contractor. And when we don't refer to any of such conditions, we simply write environmentally, circumstantially. We may say, okay, this was just informative, you have acted on this, that's fine, we close this. But there's a difference. Means notice is something that is contractual, and memos, or you can say other instructions, which are normally part of work, those are not that level, and these can be delivered by mail, this can be delivered by hand. When there was no mail, we used like internal courier system, and we used to deliver these letters or these documents to resident engineer's office or engineer's office, whatever way. So delivered by hand against receipt, or sent by mail or courier against receipt, or transmitted using either of systems of electronic transmission under whatever paragraph. Now delivered, sent, or transmitted to address for recipient's communications as stated in contact data. However, if a recipient gives a notice of another address, all notices or other communications shall be delivered accordingly after sender receives such notice. Communication, as I said, is very, very important part, as it says where these conditions state that a notice of dissatisfaction, NOD, or other communication is to be delivered, given, issued, provided, sent, submitted, or transmitted, which shall have effect when it is received or deemed to have been received at recipient's current address under subparagraph above. Electronically transmitted notice or other communication is deemed to have been received on day after transmission, provided no non-delivery notification was received by sender. All notices and all other types of communication referred to above shall not be unreasonably withheld or delayed. Where a notice of dissatisfaction is issued by party or employer's representative, paper and or electronic original shall be sent to intended recipient, and a copy shall be sent to employer's representative or other party, as case may be. All other communications shall be copied to parties and or employer's representative as stated under these conditions or elsewhere in contract. Now language. Our question is language. It is law and language. Title is law and language. It's very simple. Answer is it's not in our control. We have to accept that fact that this contract or whatever contract shall be governed by law of country or other jurisdiction which is stated in contract data, and if not stated, law of country excluding any conflict of law rules. आप कहाँ काम करते हैं? रूलिंग कहलाती है, और नहीं तो उसे मेंशन कीजिए. If there is a version of any part of contract which are written more than one language, version which is ruling language shall prevail. अगर कहीं इंग्लिश है, suppose there is English, or there is French, or there is some other language, then whatever is given that this is a ruling language, meaning of that shall stand. Language for communication shall be that stated in contract data. If no language is stated there, language for communication shall be ruling language of contract. ये आप समझिए, हम जो बात कर रहे हैं कम्युनिकेशन की, it's really very important. Means for purpose of successful communication, you should have good command of that language in which communication is to be communication is to be conducted, and also how you have to communicate, how you have to phrase in according to contract requirement, according to processing requirement. That also is. I have seen that particularly engineering community, engineers have little problem in communicating. It does not because they cannot do it, but because of their subjects involved. In engineering, generally subjects are scientific, and they don't bother about language during engineering education phase. But that is not right answer, because during those years of engineering you don't have time to learn language. But engineering working time, when you are in field, you are in profession, you do work, you have plenty of time to learn about language. It's not that you have to go to school to learn language, no. It's from practice, it's from documents, it's from dealing with people. You come in contact with many nationalities or your own people, and generally it is seen that writing is these days done by English in common for communication purpose, while speaking is not necessary that it is done, it's affected in English. It's not necessary. It can be affected in English, it can be affected in your own language, both. So you can say it's a kind of cohesive communication. It's a kind of combination of languages we use, and that's not bad, because what you think may be in your language and what you write, that's in English language or some other language. So language is not a barricade, it's only that you have to communicate clearly. What you write, it should not be ambiguous. संदिग्ध राइटिंग नहीं होनी चाहिए. ऐसी राइटिंग जो समझ ना पाए कोई, वो नहीं होनी चाहिए. और मैं नहीं समझता कि इंग्लिश में इतनी प्रॉब्लम है जो समझ ना आए. टेंसेस की बात नहीं हम कर रहे, ग्रामर की, पंक्चुएशन की बात नहीं हम कर रहे. वी आर टॉकिंग ऑफ अंडरस्टैंडिंग. Can you understand meaning of this? That is first question. I have to see whether I am able to understand this, or I understand interpretation of this paragraph. Because in contracts, there's something you cannot go word by word. You cannot go, this is a comma, this is full stop, this is apostrophe. You can't go by that. You have to understand meaning. Now, for example, this is law and language. It doesn't mean you have to understand law. You should know, okay, every country has law. So this is that law talking. Naturally, that law will prevail. And language, it's language English, it's language this and that. So I don't think it's that much difficult as far as we understand effect, essence. Essence and effect are important in contracts. You cannot sit on conditions by telling, oh no, I understand this meaning and you understand this meaning. No, you cannot say that. Experience is something else. Sometimes we don't care for many conditions. It happens. In interest of work, we move on and on and on. Together we means engineer and contractor. They move on and on and on in interest of work without bothering about what is given in contract, but it complies with requirements. For example, sometimes it's written that you have to give 24 hours notice for inspection. You have to give 48 hours notice for inspection. That is guide. It doesn't mean if you don't comply with that you will be prosecuted. That's not the case. It's only adjustment, because 24 hours notice is required because I have to prepare for that inspection. I have to study your documents. You got my point. You send a notice for inspection or may request for inspection. I have to go through drawings because I may be busy somewhere else. I am looking, maybe I look after for 4 or 5 projects and your project is one of them. So I have to plan also my work. It is for that purpose, schedule out your chart. But if you think, no, I can inspect it, there's no problem. You can come within 1 hour, half an hour, or even if you're on site, you can inspect it without even request. Request may be raised later on. So this is called adjustment. This is called how to conduct jointly, how to conduct in an integration way in interest of work. It's not because you're going to support contractor this way. It's support to work. It's not support to contractor. It's in fact support to yourself as an engineer. So there are so many issues that, of course, contract is a mandate, indeed, but mandate doesn't mean that it is everything. It's just a description of rights. It's just a description of rights, description of responsibilities, description of obligations, description of what is expected of both parties. Because ultimately, both parties are responsible. Both parties are responsible. One party is responsible for work, construction work. One party is responsible for arrangements of everything, every material, every resource, every machine, and one party is responsible for supervision and payment, and that party is employer. Of course, supervision is done by engineers, but engineers are appointed by employer and payment is arranged by employer. So it's a question of the duties and responsibilities. It's also true that without contracts, work cannot be done in mass scale or in scale which we can say where contracting professionalism is required. Why I'm saying contracting professionalism, it's something very important. Contracting professionalism, what is meaning of that? One is engineering professionalism, and I think and I understand that contracting professionalism is a part of engineering professionalism. When we say engineering, this means not only design engineering but also contract engineering. This means work engineering. This means prosecution engineering. This means, implementation. So who can implement, who can execute, who can practically, physically do that design work on site? Who can convert that design piece of paper? The design is available on that drawing on site and that is called contracting profession. Contracting profession is very responsible profession. It's not a kid's game. Here, imagination does not work, but physical work plays its role. And if contracting doesn't work, we do not believe in contracting, then we have to work ourselves. Engineer has to do itself. Then he will realize problems that are encountered in contracting. In designs, one engineer can design, two engineers can design together, three engineers can design together, or a team of designers can design together. They are only involved together. There is no physical consideration, and information is obtained and design is done. Of course, it takes time, but it is done with a team of draftsmen, with a team of something, group of designs, you can say design group. And construction is done by, if there are 4 persons in design, there will be 400 persons on site. That's the difference. You can say 1:50, 1:100 scale. That's where you know how to handle all such resources in construction is a question mark. We do not see what happens, and sometimes we abuse this term of contractor. We think of contractor as a thief, contractor is a crook, contractor is a robber, contractor can cheat. Some conception people have developed like that. Contractors think of only making money. That's one part of contract. That contractor has come because of some money, because of some profit, expected profit. Otherwise, why would contractor come? That's fact. That's truth. But is it only fact? That point is also questionable. Is it only fact? That is not only fact, that's part of facts. Fact remains that an engineer who is not experienced on contracts, who is not able to organize work activities in totality, they can only supervise. They have made themselves like this. Otherwise, construction is a part of engineering. It's very much part of engineering, and we cannot keep construction separate. We cannot affect that. Okay, don't worry about construction, just design is enough. Without construction, it is very much factual that design has got no meaning. Design is completely meaningless if construction is not done. Design of any part is meaningless if this part is not produced. And when you produce it, when you can use it and understand, study, evaluate its performance. Same way, when you do construction, you can understand design and you can understand real work. Whether your design was fine or unfine, your ease of construction or difficulty of construction would jointly tell you. When we say ease of construction means design is good. Ease means with ease, without problems, without complications, you have got this work done on site. So I can say that design is better. There are designs which can create complications, which can create difficulties on site for those people who are not experts. Now, we know all that without contracting support, I take it differently. I can say without constructing support, without construction support, we may call contractor no problem, but after all, that's also professional. You cannot keep everybody there. You cannot keep unknown there. A person, you ask a person who has been an engineer in contracting company, that person can tell you facts. You may be there yourself if you have worked in a contracting company, professional contract company. I'm not talking just whoever it is. I'm talking of where professionalism exists, where contract execution is done according to contract requirement. You can ask that engineer who has maybe got many years of experience in contracting, and that engineer can give you many solutions which you cannot take yourself. Yes, of course, you can say you are expert in designs, and that person cannot be expected of experts in design. That person may know design, of course, just like you know construction, that person may know designs. But none of you, either that person or you, are expert in reciprocals. You are expert in designs, but you are not expert in construction. That person is expert in construction, but that person is not expert in designs. So both are equal. Sum of both is called engineering. Engineering design plus engineering construction is called engineering work. I should say engineering work, because if you write equation, engineering design plus engineering construction is equal to engineering work. And what is engineering design then? Engineering work minus engineering construction is design, mathematically. So neither of you is complete if you don't have complement of each other. A building is erected, is constructed, this means work is done. How that work is done? If I say you take construction of your own house, you are a design engineer, you try, you design, okay, design you can do it, you can do it 1 week, let us say you have designed, so try construction yourself, you will get mad, I'm sure. Whatever role you have, you may be great engineer, you may be great knowledge person, but when it comes to practicality, you have to arrange all resources. You may know nothing about that. You may get no information about that. And in 1 or 2 or 3 days, you'll get mad, because you have to first calculate quantities, you have to find market sources from where at a reasonable cost you can procure this material, and you have to test yourself all this. You won't even find a laboratory for testing. I mean to say, whatever contractor does, I'm not giving credit to that, but that is a fact. Without that, we cannot get anything done. So we have to think this way, and that's what I'm calling professional contracting. I'm not calling just contracting. When professional contracting is an issue, this means works are dependent on contracting partners. Who is contractor? Is that contractor professional, or that contractor is just a fake? Everybody cannot be contractor, just like everybody cannot be builder or promoter. We'll find promoter in markets, builders in market, who got no experience, no knowledge of engineering, but they become builders, and that is tyranny. That is one point where quality lapses come in. There's one point and quality lapses appear. How can you accept a person who knows nothing about construction to become a promoter or a builder? But nobody raises this point. Nobody. And that is one reason how can we say that quality can be maintained or it can be improved. There is no way it can be done. Now I'm not here to give some bad name to someone. That's not my job. I'm talking something that is related to profession, that is related to world, and that's where we have to involve ourselves. There is nothing in contracting that doesn't relate to engineering. In fact, that's also true. When we talk of construction, we talk of engineering. Construction means engineering construction. It doesn't mean non-engineering construction. Of course, there is no requirement. People don't engage engineers. People don't engage something. They give it to some mason, some carpenter sometimes, and they do everything for them, thinking that this is engineering. And there's a difference in engineering and engineering approach. Just make construction of a wall, or just doing excavation and doing foundation without any basis, without any calculation, without any thought, and thinking everything's fine. It's not engineering, it's foolishness. You do not know about soil, you do not know about material, you do not know about anything, you do not know about movements, you do not know about framing, and you just said, I have constructed my house. Physically I have constructed, but you do not know anything about what I have constructed. Why did you construct that? आपने बना तो दिया, आपने किसी मेसन को रखा, किसी कारपेंटर को रखा, या आपने आप बना दिया सोच के मैं इंजीनियर हूँ? क्या आप बिलीव करते हैं उसमें? कुछ लोग कहते हैं क्या होता है जी, हमने देखे हैं मकान बनते हुए. आई हैव सीन मैनी हाउसेस बीइंग बिल्ट. आई हैव बिल्ट सो मेनी हाउसेस. आई नो दिस. आई नो दिस. दैट्स राइट. यू नो व्हाट, अगर आपने गलत काम किए हैं लाइफ में सारे, तो उसके लिए कौन जिम्मेदार है? उस काम को जो आपको पता नहीं, यू डिड नॉट इवन लर्न अबाउट दैट वर्क, एंड यू से हैव डन इट. देखिए, just to put steel or shutters and concrete is not engineering. First of all, what you see buildings is constructed and you do the same, that's not engineering. Engineering starts from very beginning, and that's where point lies in. Here we will talk of that sometime else, because now I'm talking on contracts, and I don't want to mix up issue, because here page open is page 9. This is priority of documents. कंस्ट्रक्शन में, कॉन्ट्रैक्टिंग में बहुत से डॉक्यूमेंट होते हैं. हाउ वी हैव टू कंसिडर देम इज़ वेरी इंपॉर्टेंट पॉइंट. कॉन्ट्रैक्ट इज़ ए पैकेज. इट्स अ पैकेज ऑफ legal documents. It's not simply documents, we can say. It is package of legal documents, and these documents do have weight. Contract means a pile of documents, and these documents have weight one by one. Some documents are there which are very much powerful, very much leading, and these are as given here. You can see documents forming contract are to be taken as mutually explanatory of one another. If there is any conflict, ambiguity or discrepancy, priority of documents shall be in accordance with given sequence. Now it's no hard and fast rule, but understanding rule. Which documents has much priority. हमने लिस्ट बनाई, लिखा कि ये हमारे दस्तावेज हैं जो इस करार के हैं, इस कॉन्ट्रैक्ट के हैं. हम ऐसे ही नहीं लिख देते, हम जिस तरह से कॉन्ट्रैक्ट कर रहे हैं इसकी वैसे ही वैल्यू है. दैट इज़ वेरी इंपॉर्टेंट पार्ट. कौन से डॉक्यूमेंट कब क्या मतलब रखते हैं, दैट इज़ व्हाट वी हैव टू सी. सो देयर इज़ अ लिस्ट ऑफ डॉक्यूमेंट. फॉर एग्जांपल, कॉन्ट्रैक्ट क्या है? कॉन्ट्रैक्ट दो पार्टी साइन करती है मिलके, उसको हम कहते हैं एग्रीमेंट. कॉन्ट्रैक्ट एग्रीमेंट, करार, या कह सकते हैं वो कागज़ जो कह रहा है हम दोनों पार्टी मिलके ये फैसला करे हैं कि ये काम इसने करना है और हमने इसको पेमेंट देनी है, उसको कहते हैं कॉन्ट्रैक्ट एग्रीमेंट. अनाउंसमेंट वही करता है, सूचना वही डॉक्यूमेंट दस्तावेज देता है कि इन दोनों पार्टी के बीच में, इस मालिक के बीच में या स्वामी के बीच में और इस ठेकेदार के बीच में ये फैसला हुआ है कि मैं ठेकेदार हूँ और ये मालिक है मेरा काम का. उसे कहते हैं कॉन्ट्रैक्ट एग्रीमेंट. इस काम को करने के लिए मुझे इतने पैसे ये देगा और मैं ये काम इसका करूँगा. और यही वो कहता है मालिक कि मैं आपको इतने पैसे दूंगा और आप मेरा ये काम कीजिए और इन हिसाब से कीजिए, इस कंडीशंस पे कीजिए. उसको कहते हैं कॉन्ट्रैक्ट एग्रीमेंट। सबसे पहला, हालांकि सबसे बाद का प्रोसेस हो, लेकिन सबसे पहला, क्योंकि जब ये डॉक्यूमेंट देते हैं तो वो फैसला कर चुका होता है कि ये काम इसने करना है। दैट्स वर्सेस कॉन्ट्रैक्ट एग्रीमेंट। वन पार्टी सेज दैट यू हैव टू डू माई जॉब, अदर पार्टी सेज यस आई विल डू दिस जॉब। One party says, what do you want for this? Other party says, I want this much amount for this. And this is time I am giving you for doing this job. And the other party says, I am accepting this time. I will deliver this on or before this time. And if I cannot deliver this, then I can pay you what you want. What your damages, I am ready to pay. And then damages are defined. And you have to do this job according to contract requirement, and contractor says, yes, I am going to do this job according to these contract requirements. I got no issue on that. The document is called contract agreement. That is document number 1, because it's telling amount. It tells this amount I'll pay you, and I says I will accept this amount. This says date of start of this document is this. Yes, this is written there. This date of start of this document. So date of completion is automatically calculated. Number 1, फिर कहते हैं particular conditions. Contract data part A and particular conditions part B, that is special provisions. Contract data हमने कहा, contract data part, particular conditions, कुछ particular हम इसलिए कहते हैं कुछ parts, जो जनरल कंडीशंस के कुछ पार्ट्स को हम रिप्लेस कर रहे हैं, कुछ पार्ट्स को अपने हिसाब से, बिकॉज वी वांट टू यूज आवर रिक्वायरमेंट्स, दे वी इम्पोज आवर पोजीशन, जो एम्प्लॉयर्स पोजीशन और कॉन्ट्रैक्टर पोजीशन इन दैट क्लॉज वी डोंट एग्री व्हाट जनरलिटी सेज, सो वी कैन अमेंड दोस जनरल क्लॉजेस, जनरल कंडीशंस, एंड दैट अमेंडमेंट of the particular condition is called general condition. Particular amendment of the general condition is named as particular condition for contract data, and also particular conditions for other provisions, which we can say special provision, विशेष points, विशेष शर्तें सामान्य शर्तें से हटाएं, उसकी जगह कुछ चेंज करके लगाएं, उसे कहते हैं पर्टिकुलर कंडीशंस, खास कंडीशंस. सो पर्टिकुलर कंडीशंस पार्ट ए, पर्टिकुलर कंडीशन पार्ट बी. पार्ट ए में कॉन्ट्रैक्ट डाटा, कॉन्ट्रैक्ट ना क्या है, व्हाट इज दिस कॉन्ट्रैक्ट, व्हाट इज ड्यूरेशन ऑफ दिस कॉन्ट्रैक्ट, what is date of start of this contract, what is date of completion of this contract, what's amount we have to pay this contractor, what are damages there, liquidated damages. Likewise, what are others, you can say special points that are binding each other, कॉन्ट्रैक्ट डाटा जिसको कहते हैं. और सेम वे कुछ दूसरी कंडीशन डाल दें, इफ़ यू जस्ट include other conditions that this is priority of this priority of that, you have to give this or whatever is there, but what is agreed with two parties, employer and contract, that all conditions are included in that. So first power goes to contract agreement, then lower power goes to particular conditions, and the much lower power goes to special provisions. Then come general conditions, means condition number 1 A is higher, particular condition B is lower than part A but higher than general conditions in considerations, and general conditions come at point number 4 here, D. Whatever conditions are there, general conditions, rule shall be done by particular conditions, while if there is no such condition as particular condition, then it shall be done by general conditions automatically by virtue of serial numbers, by virtue of precedence. And after these are contractual matters, agreements, and then comes in this same contract employer's requirement, what employers require. Now it starts what employer requires. So employer requirement is also not perfect, it's not powerful. First is contract, because this contract is also employer's requirement. Particular conditions are also employer requirement, likewise you can say. So employer's requirement comes there, and after that comes schedules, schedule you call them, whatever schedule is there, it comes at this stage. Schedules, time schedule, material schedule, or list you can say, or something else that is very important. You can say payment schedule, you can say likewise, or you can say then tender which was number one document in beginning, but now it's coming near end. And then we can say what company it is. It's proprietary, it is public limited, it's private limited, or it's joint venture undertaking. That we can say comes at that stage. And then whatever other documents forming part of contract, that can be every document. You may say specific, you may say actually specification should be somewhere there. There's some error, maybe they could not remember specification. That should be somewhere before, after general conditions, no problem. But there can be documents, you may say other document like codes, like which are not direct part of contract, guiding part of contract. Now what these are just list A, B, C, D, E, F, G, H, I, they can be J, they can be K, they can be L likewise. You can go on adding according to think, what do you think, what's best for that. And also if a party finds an ambiguity or discrepancy in documents, that party shall promptly give a notice to other party describing ambiguity or discrepancy. After even receiving such notice, employer shall issue necessary clarification or instruction. अगर किसी पार्टी को दैट किसी भी पार्टी को इसमें लगता है कि कुछ गलती हुई है, तो दूसरी पार्टी को नोटिस दें। उस जो बात आपको सही नहीं दिखती है, साफ नहीं दिखती, जिसमें डाउट लगता है, जिसमें कुछ फ़र्क लगता है, और उसके बाद वो नोटिस मिलने के बाद दूसरी पार्टी से क्लैरिफिकेशन देगी, और वो फिर क्लैरिफिकेशन एक्सेप्ट होने के बाद वो भी एक तरह से कॉन्ट्रैक्ट का हिस्सा। तो डॉक्यूमेंट्स को समझना, अब इसमें देखिए ड्राइंग्स हैं बहुत सारी, इसमें बहुत टेंडर में सब आ गया। इनफैक्ट वो टेंडर जो का है ना उसमें सब है, उसमें इसके स्पेसिफिकेशन भी है, सब है, ड्राइंग है, एवरीथिंग इज देयर। सो वी कैन से दैट डॉक्यूमेंट्स को समझना इज ऑल पैकेज, कंप्लीट पैकेज ऑफ डॉक्यूमेंट्स। देन वी कैन से व्हाट इज कॉन्ट्रैक्ट एग्रीमेंट। अभी हमने समझा तो दिया, लेकिन डिफाइन कैसे करें। इस कॉन्ट्रैक्ट कम्स इनटू फुल फोर्स, कॉन्ट्रैक्ट कम्स इनटू फुल फोर्स and effect on date stated in contract agreement. Cost of stamp duties and similar charges, if it applies, imposed by law in connection with entry into contract agreement, shall be borne by employer. If contractor comprises of joint venture, authorized representative of each member of joint venture shall sign contract agreement. सिंपल है, इसमें तो मुझे लगता नहीं कुछ एक्सप्लेन करना पड़ेगा. I don't think the question is clear. Means contract starts when starts in full force and effect as appointed date or start date mentioned in contract document, contract agreement, and stamp duty etc. This depends on law. Now, what is assignment? I'm just trying to tell you what is meaning of assignment, what is meaning of contract, and these are very important for from engineering viewpoint, that we should not run away from contract but take care of contract, because if you understand contract you can understand quality better. If you do not understand contract structure, if you do not contract content meaning like contract, then you can't apply engineering there. Engineering and contracts are complementary to each other. Without contract, engineering cannot work, and without engineering, contract cannot work. There are parties, of course, we say contracting party, employer party. Neither party shall assign whole or whatever part of contract or whatever benefit or interest in or under contract. However, either party may assign whole or part of contract with prior agreement of other party at sole discretion of such other party. आप नहीं आपने कॉन्ट्रैक्ट लिया, आपने आगे किसी को दे दिया, ये नहीं चलेगा। हमारी मर्जी हमने कर देना, ये नहीं चलेगा। आपकी मर्जी नहीं चलेगी। अगर आपने किसी को काम देना है उसके लिए आपको परमिशन लेनी होगी एम्प्लॉयर की, ये भी ज़रूरी है, क्योंकि आखिर एम्प्लॉयर का काम है, ये उसी की अथॉरिटी में आता है, वो आपको अलाउ करे या ना करे। सो वी कैन से may assign whole or part of contract, any part of contract with prior agreement of other party at sole discretion of such other party, and may as security in favor of a bank or financial institution assign parties right to whatever monies due or to become due under contract without prior agreement of other party. What it says? It says either party may assign whole or any part of contract with prior agreement to other party at sole discretion of such other party, may assign as security in favor of a bank or financial institution, assign parties right to whatever money is due or to become due under contract without prior agreement of other party. Care and study of documents. अभी डॉक्यूमेंट्स तो हैं, इनकी कौन परवाह करेगा, कैसे हम इसको रखें, वही बहुत इंपॉर्टेंट पॉइंट है। केयर एंड सप्लाई ऑफ डॉक्यूमेंट्स। हालांकि पुरानी कंडीशन है, आज के टाइम में सब कुछ इलेक्ट्रॉनिकली है, फिर भी कंडीशन तो कंडीशन है। ईच ऑफ कॉन्ट्रैक्टर्स डॉक्यूमेंट shall be in custody and care of contractor unless and until submitted to employer. Contractor shall supply to employer one paper original, one electronic copy in form as specified in employer's requirements, or if not stated, a form acceptable to employer, and additional paper copies if whatever as stated in contract data of each of contractor's documents. Each of contractor's documents shall be in custody and care of contractor unless and until submitted to employer. Contractor के पास सारे कागज़ रहेंगे उसके, जब तक कि वो इंजीनियर को या एम्प्लॉयर को उनको सबमिट ना कर दे। उस सबमिशन में ओरिजिनल पेपर जाएगा, इलेक्ट्रॉनिक कॉपी भी जाएगी, और उस फॉर्म में जाएगी जिसमें एम्प्लॉयर ने डिफ़ाइन किया है, और नहीं डिफ़ाइन किया है तो उस फॉर्म में जिसमें वो चाहता है। उसकी एडिशनल पेपर कॉपीज़ भी दे सकते हैं, जैसे भी डाटा में लिखा है। ये सब प्रोसीजर्स हैं। Contractor shall keep all times on site copy of what? Contract. Copy of contract should be on site all time, means it should be accessible on site without any problem, and this access should be to owner and to engineer, and all records under contractor's records and contemporary records, publications named in employer's requirements, that can be whatever publication, there can be references, that can be codes, or whatever else is required. Contractor's documents and variations, notices and other communications given under contract. Employer's personal, employer personal, employer's personal shall have right of access to all these documents. एम्प्लॉयर के जितने भी एम्प्लॉयज़ हैं, इंजीनियर्स हैं, जो भी हैं, सुपरवाइजर्स हैं, उनको पूरा अधिकार होगा इन डॉक्यूमेंट को पहुंचने का, पढ़ने का, समझने का, रेफर करने का, और वर्किंग आवर्स में, और वो आवर्स जो एग्री किए जाएँ कॉन्ट्रैक्टर के द्वारा. एम्प्लॉयर्स पर्सनल shall have right of access to all these documents during all normal working hours or as otherwise agreed with contractor. If a party becomes aware of an error or defect, whether of a technical nature or otherwise, in a document which was prepared by on behalf of contractor for use in execution of works, party shall promptly give a notice of such error or defect to other party. Contractor shall then promptly rectify error or defect at contractor's risk and cost. You understand this very well. कहीं भी कोई डिफेक्ट नज़र आता है, कोई एरर नज़र आती है, तो उसकी ड्यूटी बनती है कि उनको बताए, कॉन्ट्रैक्टर के बिहाफ पे बताए. कॉन्ट्रैक्टर ने क्या है कि इन ए डॉक्यूमेंट विच वॉज प्रिपेयर्ड बाय कॉन्ट्रैक्टर और यूज फॉर एक्सिक्यूशन ऑफ वर्क्स, वो एरर को नोटिफाई करना पड़ेगा जब भी समझ आए. एम्प्लॉयर्स ऑफ कॉन्ट्रैक्ट डॉक्यूमेंट्स, एम्प्लॉयर कॉन्ट्रैक्टर डॉक्यूमेंट को यूज़ करे, ये भी प्रोविज़न होता है. इट्स वेरी इंपॉर्टेंट पॉइंट. डॉक्यूमेंट दोनों के तैयार किए जाते हैं. कॉन्ट्रैक्ट के जितने भी डॉक्यूमेंट कॉन्ट्रैक्ट डॉक्यूमेंट कहते हैं. एज बिटवीन पार्टीज, कॉन्ट्रैक्टर शैल रिटेन कॉपीराइट एंड अदर इंटेलेक्चुअल प्रॉपर्टी राइट्स इन कॉन्ट्रैक्टर्स डॉक्यूमेंट्स एंड अदर डिज़ाइन डॉक्यूमेंट्स मेड बाय ऑन बिहाफ ऑफ कॉन्ट्रैक्टर. जो भी दस्तावेज कॉन्ट्रैक्टर तैयार करता है, डिज़ाइन के दस्तावेज हों, कोई भी दस्तावेज हो, इंटेलेक्चुअल दस्तावेज हो, उसका कॉपीराइट तो कॉन्ट्रैक्टर का ही है जब तक उसे ट्रांसफ़र ना किया जाए. एज बिटवीन पार्टीज, कॉन्ट्रैक्टर रिटेन्स कॉपीराइट एंड अदर इंटेलेक्चुअल प्रॉपर्टी राइट्स इन कॉन्ट्रैक्टर्स डॉक्यूमेंट्स and other design documents made by on behalf of contractor. Contractor shall be deemed by signing contract agreement to give employer a non-terminable, transferable, non-exclusive, royalty-free license to copy, use and communicate contractors documents and such other design documents, including making and using modifications of them. बड़ा इम्पोर्टेंट पॉइंट है, बहुत इम्पोर्टेंट पॉइंट है समझने के लिए, क्योंकि यहाँ बात कर रहे हैं लाइसेंस की, कॉपीराइट की. कॉन्ट्रैक्टर शैल बी डीम्ड, माना जाएगा कॉन्ट्रैक्टर ने कॉन्ट्रैक्ट साइन किया तो ये भी साइन किया. कॉन्ट्रैक्टर शैल बी डीम्ड बाय साइनिंग कॉन्ट्रैक्ट एग्रीमेंट टू गिव टू एम्प्लॉयर ए नॉन टर्मिनेबल, ट्रांसफरेबल, नॉन एक्सक्लूसिव, रॉयल्टी फ्री license to copy, use and communicate contractors' documents and such other design documents, including making and using modifications of them. साफ कहते हैं कि जो साइन किया है आपने कॉन्ट्रैक्ट, इसका मतलब आपने ये भी साइन किया है जो भी डॉक्यूमेंट्स आप देंगे, जो भी डिज़ाइंस के देंगे, किसी और कार्य के देंगे, वो लाइसेंस है आपके डॉक्यूमेंट्स का, जिससे एम्प्लॉयर या इंजीनियर को यूज़ कर सके, डॉक्यूमेंट्स को ट्रांसफ़र कर सके आगे, इस पर्पस के लिए कम्युनिकेशन कर सके उन डॉक्यूमेंट्स की, ये सब उसमें लाइसेंस्ड है। और वो क्या कहता है, इस लाइसेंस का क्या मतलब है? दिस लाइसेंस मीन्स व्हाट? दिस लाइसेंस shall apply throughout actual or intended operational life, whichever is longer, of relevant parts of works. This license shall apply throughout actual or intended operational life, whichever is longer, of relevant parts of works. Entitle person in proper possession of relevant parts of works to copy, use and communicate contractors' documents and such other design documents for purposes of completing, operating, maintaining, altering, adjusting, repairing and demolishing works. This is also a very important one. Entitle whatever person in proper possession of relevant parts of works to copy, use and communicate contractors' documents and such other design documents for purpose of completing, operating, maintaining, altering, adjusting, repairing and demolishing works. In case of contractors' documents and such other design documents which are in form of electronic or digital files, computer programs and other software, permit their use on whatever computer on site and or at locations of employer and employer's representative and or at other places as envisaged by contract. कहीं भी वो कागज हो, in case of contractors' documents and such other design documents which are in form of electronic or digital files, computer programs and other software, permit their use and use on whatever computer on site and or at locations of employer and employer's representative and or at other places as envisaged by contract. And in event of termination of contract, जब कॉन्ट्रैक्ट को आप ख़त्म कर रहे हैं, जब कॉन्ट्रैक्ट को ख़त्म किया जा रहा है बिफोर टाइम, termination of contractor's default. In event of termination of contract, termination for contractor's default, entitle employer to copy and communicate contractor's documents to and to user and other design documents made by or for contractor. Termination of employer's convenience, termination for employer's convenience, termination by contractor or subclause, entitle employer to copy, use and communicate contractor's documents for which contractor has received payment for purpose of completing works and or arranging for whatever other entities to do so. Contractor's documents and other design documents made by or on behalf of contractor shall not, without contractor's prior consent, be used, copied or communicated to third party by or on behalf of employer for purposes other than those permitted under this subclause. Contractor's document and other design documents made by or on behalf of contractor shall not, without consent, I am getting a thought problem, without contractor's prior consent, be used, copied, or communicated to a third party by or on behalf of employer for purposes other than those permitted under this laws. Now, contractor's use of employer's document. Contractor's use of employer's document. It's also very important point here. Contractor's use of employer's document. Now, as between parties, employer shall retain copyright and other intellectual property rights in employer's requirements and other documents made by or on behalf of employer. Contractor may, at contractor's cost, copy, use and communicate these documents for purpose of contract. These documents, in whole or in part, shall not without employer's prior consent be copied, used or communicated to a third party by contractor except as necessary for purposes of contract. Confidentiality, very important बात. Confidentiality very important. We cannot take it just for granted, but it's very significant part on contract. Confidentiality. So there is no secret in this, but confidentiality due to commercial reasons. Is very significant here. Contractors shall disclose all such confidential and other information as employer may reasonably require in order to verify contractor's compliance with contract. Contractor shall disclose all such confidential and other information as employer may reasonably require in order to verify contract's compliance with contract. कॉन्ट्रैक्टर वो सारी बातें बताएगा एम्प्लॉयर को जो एम्प्लॉयर जानना चाहता है और उसकी आवश्यकता उसको हो, ये भी लगता हो, वो पता लगा सके कि कॉन्ट्रैक्टर ने कॉन्ट्रैक्ट पे कंप्लाई किया है या नहीं किया है. Contract shall treat all documents forming contract as confidential. Contract shall treat all documents forming contract as confidential, except to extent necessary to carry out contractor's obligations under contract. क्योंकि ये डिज़ाइन कॉन्ट्रैक्टर का नहीं है या ये प्रोप्राइटरी कॉन्ट्रैक्टर के नहीं है, आप यूज़ करेंगे एज कॉन्ट्रैक्टर, लेकिन वहाँ तक जहाँ तक उसकी ज़रूरत है. कॉन्ट्रैक्टर शैल ट्रीट ऑल डॉक्यूमेंट्स फॉर्मिंग कॉन्ट्रैक्ट एज कॉन्फिडेंशियल एक्सेप्ट टू एक्सटेंट necessary to carry out contractor's obligations under contract. Contractor shall not permit to be published or disclose any particulars of contract in any trade or technical paper or elsewhere without contractor shall disclose all such confidential and other information as employer may reasonably require in order to verify contractor's compliance with contract. Contractor shall treat all documents forming contract as confidential except to extent necessary to carry out contract's obligations under contract. Contractor shall not permit to be published or disclose any particulars of contract in any trade or technical papers or elsewhere without employer's prior consent. It's very significant part for engineers to understand that you cannot do anything to abuse these documents without getting consent from owner. Contractors shall treat all documents forming contract as confidential. All documents as confidential except to extent necessary to carry out contractor's obligations under contract. Contract shall not permit to be published, shall not publish or permit to be published or disclose whatever particulars or any particulars of contract related to whatever trade or any trade or technical papers or elsewhere without employer's prior consent. Employer and employer's personnel shall treat all information provided by contractor and marked confidential as confidential. Employer and employer's personnel shall not disclose. Employer and employer's personnel shall not disclose or permit to be disclosed any such information to third parties except as may be necessary when exercising employer's rights under termination of contract's default. A party's obligation of confidentiality under this subclause shall not apply where information was already in that party's possession without any obligation of confidentiality before receipt from other party, becomes generally available to public through no breach of these conditions or is lawfully obtained by party from a third party which is not bound by any obligation of confidentiality. Compliance with laws. Compliance with laws. Contractor and employer. Contractor and employer shall, in performing contract, contractor and employer means both parties shall, in performing contract, comply with all applicable laws unless otherwise stated in employer's requirement. वो कॉन्ट्रैक्टर हो या एम्प्लॉयर हो, जब वो कॉन्ट्रैक्ट को काम कर रहे हैं, परफॉर्म कर रहे हैं, उस जगह के जितने भी नियम, कानून, अधिनियम हैं उनके साथ चलेंगे, उनको मानेंगे. Unless otherwise stated employer's requirement, employer shall obtain or shall have obtained planning, zoning or building permit or similar permits, permissions, licenses and or approvals for permanent works and on any other permits, permissions, licenses and or approvals described in employer's requirements as having been or being obtained by employer. Employer shall indemnify and hold contractor harmless against and from consequences of whatever delay or failure to do so, unless failure is caused by contractor's failure to comply with subparagraph below. What does it say? Contractor shall give all notices. Contractor shall give all notices, pay all taxes and fees, taxes, duties and fees, and obtain all other permits, permissions, licenses and approvals as required by laws in relation to execution of works. Contractor shall indemnify and hold employer harmless Contractor shall give all notices, pay all taxes, duties and fees, obtain all other permits, permissions, licenses and or approvals as required by laws in relation to execution of works. Contractor shall indemnify and hold employer harmless against and from consequences of whatever failure to do so, unless failure is caused by employer's failure to comply with assistance clause. Within time stated in employer's requirements, contractor shall provide such assistance and all documents as described in employer's requirements or otherwise reasonably required by employer so as to allow employer to obtain any permits, permission, licenses or approvals under above. And then within time stated employer's requirements, contractor shall provide such assistance and all documentation as described in employer's requirements or otherwise reasonably required by employer so as to allow employer to obtain whatever permit, permission, license or approval under article subparagraph Contractor shall comply with all permits, permissions, licenses, and or approvals obtained by employer under paragraph above. If having complied with subparagraph above, contractor suffers delay or incurs cost as a result of employer's delay or failure to obtain permit, permission, license or approval under this clause above, contractor shall be entitled subject to claims for payment and or extension of time and or payment of such cost plus profit. If employer incurs additional cost as a result of contractor's failure to comply with above period that employer shall have complied with, employer shall be entitled subject to claims for payment and EOT to payment of these costs by contractors. Joint and several liability. Joint venture, we are talking दो कंपनियां, दो से ज़्यादा कंपनियां एक साथ मिल जाएं, अलायंस बन जाए. If two or more contracting companies come together and constitute one alliance, which we can say joint venture, JV. And what is their combined responsibility is several liability. Members of joint venture, JV, shall be jointly and severally, severally, liable to employer for performance of contractor's obligations under contract. JV leader, joint venture leader, shall have authority to bind contractor and each member of JV. Neither members nor scope and parts of work to be carried out by each member, nor legal status of JV. Neither members nor scope or parts of works to be carried out by each member, nor legal status of JV shall be altered without prior consent of employer, but such consent shall not relieve altered JV from whatever liability under paragraph above. Limitation of liability. Neither party, limitation of liability, neither party shall be liable to other party for loss of use of works. Neither party shall be liable to other party for loss of use of works, loss of profit, loss of any contract or for any indirect or consequential loss or damage may be suffered by other party in connection with contract other than under. That is delay damages, variation by instruction, payment after termination for employer's convenience, payment and termination by contractor, intellectual and industrial property rights, indemnities by contractor, indemnities by employer. These are few points that we have to understand. That is liability and that is limitation of liability. We have to consider this. See, these conditions are of course getting little complicated, but it is a job. एवरीथिंग कैन नॉट बी ईजी, हर चीज़ आसान नहीं होती है. कॉन्ट्रैक्ट है, इसमें समझना ज़रूरी है. आप इसमें एडवोकेट नहीं बन जाएंगे, होना ही ज़रूरत है। डॉक्यूमेंट्स के मतलब को समझना, वर्क के मतलब को समझना, उनके इफेक्ट्स को समझना। जब तक आप वो नहीं समझेंगे, इन डेटा में मच चाहिए ये गवर्नमेंट देती है। हम लिमिटेशन लाइबिलिटी की बात कर रहे हैं, और लाइबिलिटी कॉन्ट्रैक्ट में बहुत बड़ी, कॉन्ट्रैक्ट अपने आप में करना ही लाइबिलिटी है। बड़ा कॉन्ट्रैक्ट बड़ी लाइबिलिटी, छोटा कॉन्ट्रैक्ट छोटी लाइबिलिटी। कॉन्ट्रैक्ट को समझना, उसकी धारा को समझना, उससे पब्लिक ओपिनियन को समझना। You must have talked someone about quality. You must not be happy, or that person might not be happy. That's okay. But responsibility is responsibility. Sometimes we don't care for quality and we say we have done it. That's false. You did not care for quality, you have said you have done it. This means you have been a part of non-quality system. You did not worry about quality, you did not care for that. You do not respect quality, and that's where a problem lies in. So you can say liability is something in contracts. The damages are damages, means it says neither party shall be liable to other party for loss or use of any works, loss of profit, loss of any contact, or for any indirect or consequential loss or damage which may be suffered by other party in connection with contract, other than delay damages, variation by instruction, payment after termination for employer's convenience, payment after termination by contract, and intellectual, industrial property rights, then indemnities by contractor, and can say indemnities by employer, material, employer supplied material and employers equipment, temporary utilities, intellectual and industrial property rights, indemnities by contractor. Likewise, it's really भाई डिले होती है, if contractor has done delay, contractor has to pay liquidated damages if these are mentioned. If these are available in contract data, either you have to recover lost time, or you have to share, you have to give back something to employer for delays, and we can say that is delay damages. Variation by instruction. There occurs some variation due to whatever reason, due to site instructions or engineer's instructions, or due to that. That's called variation. It can be plus or minus. Whatever amount comes in, that is to be placed in, and you have to find out what is final amount. Then after termination, payment after termination for employer's convenience. If employer terminates contract because that employer finds some better state, that employer has responsibility for their building a you have to take this point. If employer terminates for its convenience on contract when termination doesn't have justification, then it's interest of employer. So employer gets benefit by terminate contract, unknown benefit, that is liability for employer cause contract would claim. So that point must be kept in view. Likewise, we can go on, and we can understand how to handle this, how to do it. I'll take some time to go upstairs, and meanwhile I think if you can, I'll go up and see how it is done. 5 minutes, 10 minutes maximum. I'll be back. Meanwhile we'll go. here, and in same way I'm just trying to give you back again what was expected of this. And this contract industrial property rights, indemnities by employer. Likewise, total liability of contractor, you can talk of, and to employer under or in connection with contract, that is employer supplied materials, employer's equipment, temporary utilities, intellectual and industrial property rights, indemnities by contractor. Now, all these shall not exceed sum stated in contract data, and if a sum is not so stated, contract price stated in contract agreement. Subclause shall not limit liability in any case of fraud, gross negligence, deliberate default, or reckless misconduct by defaulting party. Contract termination is very different and a kind of powerful and horrifying clause. Horrifying in a sense for contractors. Contract termination. Now, subject to whatever mandatory requirements under governing law of contract. Termination of contract under these conditions shall require no action of whatsoever kind by either party other than the stated herein. What's that? Right of access to site. Now, what it says? Employer shall give contractor right of access. Right of access to and possession of all parts of site within time stated in contract data. It says employer shall give contractor right of access to and possession of all parts of site within time or times stated in contract data. कॉन्ट्रैक्टर को एम्प्लॉयर पूरे राइट्स देगा साइट पे जाने के, साइट को पकड़ने के, रहने का मतलब वहाँ ठहरने के और काम करने के, उस समय के अंदर जो समय कॉन्ट्रैक्ट डाटा में दिया गया है उससे पहले. राइट एंड पोजेशन में नॉट बी एक्सक्लूसिव टू कॉन्ट्रैक्टर. ये सिर्फ कॉन्ट्रैक्ट के राइट नहीं होंगे, अधिकार नहीं होंगे, या उसको वहाँ पकड़ना अधिकार नहीं होगा. If under contract, employer is required to give to contractor possession of any foundation, structure, plant or means of access, the employer shall do so in time and manner stated in employer's requirement. However, employer may withhold any such right or possession until performance security has been received. I repeat, employer shall give contractor every right of access to and possession of all parts of site within time stated in contract data. This right and possession may not be exclusive to contractor. If under contract, employer is required to give to contractor possession of foundation, structure, plant or means of access, employer shall do so in time and manner stated in employer's requirements. However, employer may withhold whatever such right or possession until performance security has been received. Performance security must be given immediately while contract is received. It's mandate because it is protection to employer. कॉन्ट्रैक्ट में जो भी आपको एरिया मिलना चाहिए टाइम के हिसाब से जो भी दिया गया मिलना चाहिए, कोई भी और फैसिलिटी या रिक्वायरमेंट फाउंडेशन की, स्ट्रक्चर की, प्लांट की, कुछ भी है उस पर पहुँचने की मिलनी चाहिए तो मिलनी चाहिए, उसमें कोई देर नहीं होनी चाहिए। एक्चुअल तो यही है, वास्तव तो यही है। In no such time, if no such time is stated in contract, data employer shall give contract right of access to and possession of site with effect from commencement date. अगर ऐसा कोई टाइम कॉन्ट्रैक्ट में नहीं दिया गया है कि कितने समय में आपको एक्सेस मिलेगी, राइट मिलेगा, तो आपको जैसे ही कमेंसमेंट डेट स्टार्ट होती है वो मिलना चाहिए। If no such time is stated in contract data, employer shall give contractor right of access and access to and possession of site with effect from commencement date. If contractor suffers delay, if contractor suffers delay and or incurs cost as a result of failure by employer to give such right, to give whatever such right or possession within such time, contractor shall be entitled subject to claims for payment clause or subject to EOT, that is extension of time clause, for payment of such cost plus profit. However, if and to extent that employer's failure was caused by whatever errors or delay by contractor, including errors in or delay in submission of whatever applicable contractor's documents, contractor shall not be entitled to such extension of time and or cost plus profit. So these two conditions jointly apply. It says if contractor suffers delay, अगर contractor को देरी होती है साइट मिलने में, जो भी खर्चा कॉन्ट्रैक्टर के इसके ऊपर आएगा, डिले का एक्सटेंशन टाइम आएगा, वो उसको मिलेगा। If contractor suffers delay and or incurs cost as a result of a failure by employer to give such right or possession within such time, contractor shall be entitled subject to claims for payment and or EOT to EOT and or payment of such cost plus profit. However, if and to extent that employer failure was caused by an error or delay by contractor, including an error in or delay in submission of any of applicable contractor's documents, contractor shall not be entitled to such EOT and or cost plus profit. If under contract, employer is required to give contractor possession of foundation, structure, plant or means of access in accordance with contractor's documents, contractor shall submit such contractor's documents to employer in time and manner stated in employer's requirement. साइट मिलना ज़रूरी है, नहीं तो काम कैसे होगा। साइट की एक्सेस मिलना ज़रूरी है, नहीं तो जाएंगे कैसे। लेकिन जो फॉर्मेलिटीज़ होती हैं वो तो पूरी करनी पड़ेंगी, ये भी आपको मानना चाहिए। नहीं करेंगे तो प्रॉब्लम तो आएगी ही। और इसमें मैं समझता हूँ दोनों का कहीं ना कहीं फॉल्ट हो सकता है। असिस्टेंट सहायता, if requested by contractor if requested by contractor, employer shall promptly provide reasonable assistance to contractor so as to allow contractors to obtain copies of laws of country which are relevant to contract but are not readily available. Permits, permission, licenses or approvals required by laws of country, including information required to be submitted by contractor in order to obtain such permits, permissions, licenses or approvals, which contractor is required to obtain under compliance with laws for delivery of goods, including clearance through customs and for export of contractor's equipment when it is removed from site. And other contractors. One by one, we are going further to understand these clauses, these conditions on silver contract, silver book, which is EPC, and this is now employers, personal and other contractors. Employers shall be responsible for ensuring that employers' personal and employers' other contractors are near site, cooperate with contractors' efforts under cooperation clause, comply with same obligations which contractor is required to comply with under health and safety obligations and protection of environment. Contractor may require employer to remove or cost to be removed in person of employer's personal or employer's other contractors, if whatever, who is found based on reasonable evidence to have engaged in corrupt, fraudulent, collusive or coercive practice. अगर कॉन्ट्रैक्टर चाहे, आवश्यक समझे, एम्प्लॉयर से कह सकता है कि ये आदमी गलत है, आपका करप्ट है, भ्रष्ट है, धोखेबाज है और गलत काम करता है, हमारे साथ कॉर्सिव काम करता है, दबाता है अननेसेसरी, उसके लिए वो कह सकता है इसको यहाँ से हटाएं. एम्प्लॉयर्स फाइनेंशियल अरेंजमेंट्स, बहुत इंपॉर्टेंट क्लॉज, कंडीशन. एम्प्लॉयर्स अरेंजमेंट्स फॉर फाइनेंसिंग employers' obligations under contract shall be detailed in contract data is something different. Employers' arrangements for financing employers' obligations under contract shall be detailed in contract data. If employer intends to make whatever material change affecting employer's ability to pay part of contract price remaining to be paid at that time as estimated by employer to these financial arrangements, or has to do so because of changes in employer's financial situation, employer shall immediately give a notice to contractor with detailed supporting particulars. Again, एम्प्लॉयर के इंतज़ाम, एम्प्लॉयर का प्रबंधन, वो पैसा इस कॉन्ट्रैक्ट के लिए कहाँ से लाएंगे, वो देना चाहिए विवरण कॉन्ट्रैक्ट डाटा में। अगर एम्प्लॉयर ने कुछ बदला उसमें, उन अरेंजमेंट्स में, उन इंतजामों में, और वो जानता है कि कॉन्ट्रैक्ट प्राइस किस समय देना है, कितना देना है, एस्टिमेट करता है, उसके लिए अरेंजमेंट्स कैसे होंगे, उसके बारे में वो तुरंत ठेकेदार को बताएगा कि ये पैसा आपको तब मिलेगा। Employers' arrangements for financing employers' obligations under contract shall be detailed in contract data. If employer intends to make material change affecting employer's ability to pay part of contract price remaining to be paid at that time as estimated by employer to these financial arrangements, or has to do so because of changes in employer's financial situation, employer shall immediately give a notice to contractor with detailed supporting particulars. If contractor receives an instruction to execute a variation, if contractor receives an instruction to execute a variation with a price greater than 10% of contract price stated in contract agreement, or accumulated total of variations exceeding 30% of contract price stated in contract agreement, does not receive payment in accordance with clause payment, and becomes aware of a material change in employer's financial arrangements of which contractor has not received a notice under this clause, contractor may request an employer shall within 28 days after receiving this request provide reasonable evidence the financial arrangements have been made and are being maintained, which would enable employer to pay part of contract price remaining to be paid at that time as estimated by employer. This important clause says if contractor receives an instruction to execute a variation with a price greater than 10% of contract price, वेरिएशन का प्राइस, चेंज का प्राइस 10% से ज़्यादा नहीं होना चाहिए अगर हुआ तो, और टोटल वेरिएशंस 30% से ज़्यादा हो गई तो, और कम accumulated total of variations exceeds 30% of या उसको पता चलता है कॉन्ट्रैक्टर को कि पैसे का इंतजाम कहाँ हो रहा है, कैसा हो रहा है, नहीं मालूम, तो कॉन्ट्रैक्टर की ऐसे ही नोटिस जाती है, रिक्वेस्ट जाती है एम्प्लॉयर को 28 डेज में, और रिक्वेस्ट मिलने के बाद उसको अरेंजमेंट्स का बताना होगा और कि हमारे आपके इंतजाम हो चुके हैं, चिंता ना कीजिए, आपको पेमेंट मिलेगा। Employer shall have made available to contractor for information before base date all relevant data in employer's possession on topography of site and on subsurface, hydrological, climatic and environmental conditions at site. Employer shall promptly make available to contractor all such data which comes into employer's possession after base date. Original survey control points, lines and labels of reference, items of reference in these conditions shall be specified in employer's requirements. Employer shall have no responsibility for accuracy, sufficiency or completeness of such data and or items of reference except as stated in general design obligations. It is site data and items of reference. Site data and items of reference. Base date means 28 days before issue of tender. Close of tender. Base date means 28 days before or 4 weeks before when tender is submitted. Employer shall have made available to contractor for information before base date all relevant data in employer's possession on topography of site and on subsurface, hydrological, climatic and environmental conditions at site. Employer shall promptly make available to contractor all such data which comes into employer's possession after base date. Original survey control points, lines and labels of reference, items of reference in these conditions shall be specified in employer's requirements. Employer shall have no responsibility for accuracy, sufficiency or completeness of such data or items of reference except as stated in subclause General Design Obligations. Interestingly, it's contract after all, and we have to be clear. We have to be clear about what is required to be done. I have explained you up to certain points, and there are so many more points that it will take many talks to explain whole contract. It cannot be explained in one day. We cannot share our views in one day. It takes time because it's a question of contract. Contracts which are in fact very complicated, which is a very complicated word. It's a part of engineering profession, but it is not easy part. We cannot take it granted. We take it for granted that we understand. No. You see, project takes many years. Every project runs for many years, and you can say if you have to write some documents which are going to work, which shall work for years to come, you cannot prepare those documents in 1 hour or 2 hours, because those documents impact on project. Similarly, there will be many hundreds of thousands of documents, probably technical and non-technical, commercial and non-commercial, you can say. All classes of documents become part of contract. It's not simply that we have something, everything that's okay. It's complete document. It's complete system. You can say contract is a system in fact. कॉन्ट्रैक्ट एक सिस्टम, एक ढांचा है और वो मजाक नहीं है. कॉन्ट्रैक्ट का ढांचा मजाक नहीं है, वो एक इंजीनियरिंग का हिस्सा है. कॉन्ट्रैक्ट का इंजीनियरिंग का हिस्सा होना बहुत बड़ी बात है. लोग समझते नहीं हैं, कॉन्ट्रैक्ट को मजाक में ले लेते हैं, देखा जाएगा जो हुआ, विल सी व्हाट टू डू. लेकिन हम भूलते हैं क्वालिटी सेफ्टी, कॉन्ट्रैक्ट, प्रोडक्ट सब एक ही है. कॉन्ट्रैक्ट की क्वालिटी क्या है? इट डिपेंड्स व्हाट कॉन्ट्रैक्ट वी हैव डन. इज इट वर्थ, इज इट प्रोफेशनल or it's not professional. That is what we have to see. What quality it has got in, we have to see. Because it's no joke. Contract is no joke. It's life of work. If contract is dirty, you can say it shall be very difficult to focus on that. Our purpose is not to scare someone, but to share facts about contracting. These documents stand tests for many years to come. You see, drawings, designs, specifications, quantities, quality, safety, multidiscipline, all involvements, and contract. All these are called contract basis, contract supports, and contract documents. Documents, contract agreement, and contract documents. If you say contract documents, you can list them. You may find thousands in some cases and hundreds in some cases, depending on what sort of project it is and how long it has to go. Sometimes projects have many components and sometimes only one component. If project has got many components, wider one area, complications, multidisciplines involvement, it would have many hundreds and many thousands documents probably. And every document has some importance, some significance. As we said in our list of priorities, what is prior one? From first priority to last priority, every document plays its role. And that role we have to comprehensively understand. It's something that you learn by virtues of experiences, by virtues of your pickup, and by virtues of what guidance you got from your seniors or with those professionals with whom you worked or you taught. It's for everyone. It's not simple one page or two page. It should be comprehensive understanding, and it's very significant part of execution engineering, or you can say engineering that works. We cannot just take it lightly and leave it to circumstances. Okay, it shall be done. Every work requires to be done under controls, through controls, by controls. Controls means cost, time, quality, all other technological requirements and resources, risks, and whatever could happen or may happen. Every issue is to be controlled, and controls means contract. Controls means engineering. Controls means cost. Controls means time. And controls means all inputs that are affected and outputs. We have to deliver. Remember in mind. We have to deliver, and that delivery is of utmost significance. Nothing can be taken for granted. That's also true. We can't take something, okay, we will do it. Yes, we will do it, but when? Question arises, when, how, what way? Those points must be taken care of. something that has to be done in years to come, cannot be decided just one go. We have to be very careful about this सालों साल चलने वाली बात, सालों साल वर्षों तक चलने वाले कॉन्ट्रैक्ट्स। ना तो इनके दस्तावेज एक दिन में तैयार हो सकते हैं, महीनों लग जाते हैं, कई बार तो बहुत टाइम लग जाता है। और पहले तो था कि कई कई साल लग जाते थे, आज वो चीज़ तो नहीं है, लेकिन फिर भी टाइम तो लगता है। कॉन्ट्रैक्ट को समझना होगा अच्छी तरह से और तभी बात बन सकती है। इसको हम ऐसे ही नहीं ले सकते, मजाक में नहीं ले सकते। ये बात भी बहुत ज़रूरी है समझने। Once we understand all this, cannot be taken for granted. It cannot be taken, we know it. Every condition of contract is important. Every part of specification is important. Every part of contract is important. Every priority is important, and we cannot go without that. And if we go without that, we make mistakes. That's true. As we said in this title, it is life. Life of what? It's personal life, it's contract life, it's project life, or what here we say? We say here, in case of contract, life of project construction, and also it is related to operational life of that project. If construction happens in a reliable way, if everything goes on smooth, well, I think it doesn't happen, but if it goes on smooth, that's fine way you can say, that's best way we can say. सब कुछ ठीक हो जाए कुछ ज़रूरी नहीं है, लेकिन ठीक होना चाहिए। कॉन्ट्रैक्ट की इम्प्लीमेंटेशन ठीक होनी चाहिए, ये भी ज़रूरी है। वो तभी होगा ना जब कॉन्ट्रैक्ट ठीक होगा, कॉन्ट्रैक्ट प्रोफेशनल होगा, कॉन्ट्रैक्ट क्लियर होगा, कॉन्ट्रैक्ट की लाइफ, कंस्ट्रक्शन की लाइफ और उसके बाद उसको चलाने की लाइफ, प्रोजेक्ट जो कहा उसको ऑपरेट करने की लाइफ, दोनों में फंड है। Inputs in contract, we can raise questions. We cannot go without explicitly clear contracts. We cannot do anything as such. That is also very true. We have to be responsible in that way. How to move ahead? We will find difficulties in contracts because of people who are inexperienced or who deal with contracts without having any strong, sound basis of contract. Contract means where money is involved, resources are involved, time is involved, and you can say because of delays, performance is involved. Performance of contracts, construction contracts, performance of EPC contracts, performance of operation for which entire work is done. If one is delayed, consequentially all others are delayed. And that should not happen, but it happens. That should be curtailed, that should be recovered, that should be taken care of, that should be cured. And that's where engineers are required. Experience is required. Quality is required. Quality in every act, quality in all acts, quality in contract composition, contract structure. Undue should not be taken in and due should not be left out. Those required facts must be taken care of. And if we miss one point, certainly sequential points shall be missed. Designs is a part of contract when it is EPC. This means it's powerful contract. Design to be done, then construction to be done. And construction means lot. There is no solution to construction. There may be computers now, there may be softwares, there may be coordination programs, but softwares cannot replace human input. Data can be wrong, everything can be wrong, it happens. So clarification, clear clarification is of significance while talking of contracts. Very important point it is. We say we refer to AnnexSL, of course we refer to quality system, but that system cannot operate on its own. Cannot operate on its own. That system requires professional input. That system requires totality of professionalism. And professionalism means quality and quantity, timely requirement. If we cannot do that, we cannot follow that. It's easy to make a plan, it's easy to draw a bar chart or CPM or PERT, but it's not easy to implement that. It's not easy to implement that because of varying reasons. And those reasons are lack of experience or lack of knowledge. If there is lack of knowledge, lack of experience, there shall be errors. We have to care about contracts. Care about contract from implementation viewpoint, from performance viewpoint. We can say reliability for prosecution and performance, and for long-term performance. Contracts must be explicitly clear and competent, with having consistency, pertinent pertinent quality issues. चलो ये लगता है ऐसे कैसे नहीं pertinent quality issues. Easy to say sometimes, but it's not easy to realize. It's very easy to speak, but it's difficult to do. Entry of documents into your mind and entry of your mind into documents both are important. If I cannot understand what document is, just like we cannot understand drawings, how can you do job? If you do not understand contents of drawings, if you do not contents sections, elevations, standard drawings, if you cannot correlate all these within same discipline or along with other disciplines, we cannot decide what work has to go or what work we are doing, is that right or not right. In fact, until it's clear, we cannot move on work. Same way, if we are not clear in contracts, what is requirement of contracts, what are various liabilities, we cannot decide or we cannot even submit our bid. This point we have to be very serious about. Bid submission is not enough, because once we submit bid, we take responsibility, and once we enter into contract, if bid is successful, that is another commitment that we have to do this job. And in fact, it's not a privilege, it's a binding. It's a binding on both parties, and it is higher binding on contracting party, because contractor has to do it. कॉन्ट्रैक्टर को काम करना पड़ेगा. बिड डालने से बात नहीं बनती, बिड जीतने से भी बात नहीं बनती कि काम हमको मिल गया, खुश हो जाते हैं, बहुत बड़ा काम मिल गया. गलती भी हो सकती है, हम जानते हैं, लेकिन हम समझते हैं बहुत अच्छा हुआ, हमें काम मिल गया, हम मैनेज कर लेंगे. एक आदत बन गई है लोगों की, मैनेज कर लेंगे. मुझे मतलब समझ नहीं आता क्या मैनेज कर लेंगे, मेरे साथ बहुत कुछ ऐसा हुआ. फिर मैनेज कीजिए आप, कहने का मतलब है चोरी कीजिए आप, हेरा फेरी कीजिए आप, जो कर सकते हैं कीजिए, इसमें करिए, ठीक नहीं है. कॉन्ट्रैक्ट लेना या नहीं लेना, इसका मतलब ये नहीं जो कॉन्ट्रैक्ट नहीं ले पा रहे वो बेवकूफ़ हैं. नहीं, वो शायद आपसे ज़्यादा समझते होंगे या उनकी कोई प्रॉब्लम होगी, वो लेना नहीं चाहते. कॉन्ट्रैक्ट कॉन्टेंट्स को अंडरस्टैंड कीजिए, कॉन्ट्रैक्ट्स आफ्टर मैथ्स को अंडरस्टैंड कीजिए. कॉन्ट्रैक्ट खिलौना नहीं है, याद रखना, ये एक रिस्पॉन्सिबिलिटी है, ये एक लायबिलिटी है, एंड दिस ट्रांसफर्स टू योर चिल्ड्रन आल्सो. If you are employer, by virtue of operation of law, this transfers by inheritance to your kids. and it is very severe binding according to contract law. You cannot, if you think I die, my responsibility is over. No, it's not over. It continues on same foundation, on same strength on which you won this contract. Therefore, don't think always getting successful, having a contract won is a business promotion. Until you are not clear, don't take any contract. Until you are not clear, until you means you are not sure. If you are sure, yes, it's fine. Then remember, you have to do that contract job. You have to do it. You cannot simply skip. No, skipping is not allowed. If you skip, you would suffer, and that is fact of life. One should be clear about this. I'm just giving you concluding this statement in this case because I want to take now off after 3 hours approximately, and it is also festival of Diwali. I would say don't get excited because contract is contract. It's not a job, it's not an employment, it is a commitment and a binding, and on both parties, employer and contractor, both are bound by provisions of contract. It's not contract form that, it's not simply contract agreement that is to be signed and executed. It's all pages of contract, all 1 to 10,000, 1 to 50,000 or 1 to 1, whatever it is. Every page requires to be signed, and that is what contract is. Sometimes I remember jokes in contract meetings. Oh, you signed this contract. You can't say no. You signed not only this contract but also each and every page of this contract, documents, all drawings, everything. You signed each and every page of that. This was a taunting answer to some question that contractor raised but should not have raised for certain concession. Well, I'm just giving you relief. But don't worry. Don't be negative. If you understand very well, if you have professional capacity, if you understand plus and minus of requirements of contract, based on that only you can calculate, and you should calculate. Otherwise, maybe you lose. Don't get disheartened because party or partner, you can say competitor, who gets that job may also not be happy due to some compulsion. That party might have gone for lower price, but here question is not price alone, question is capacity, and that capacity is very significant, very important. We must be very serious about that issue. Otherwise, contract is not friend of anybody. It's not friend of someone. It's friend of none. It's friend of none, and I can say friend of none. So I would say that if you want to raise some question, practical question, you can send me onto this mail suraj_engineer@yahoo.co.uk or Gmail. You can say Suraj Singh, surajsingh pe@gmail.com. Don't call me because calling is not required. Send me mail if you wish to write something, or you can raise question on Facebook, or you can raise question on LinkedIn. It's up to you. This link is also given on Structural Engineers Forum of India. Thank you very much. I shall see you again. Hope you enjoyed this.